Hello friends, today we are beginning a new video series which is titled How to Become an Expert in the Constitution of India. And what is good about this is that we'll become experts in the Constitution of India in just 20 minutes a day. In fact, less than 20 minutes a day. This is presented by me, Advocate Siddharth Arora, from the Supreme Court of India. This is about me. As I've already told, I'm a practicing advocate in the Supreme Court of India. I've authored a book called as History of the Constitution of India. And I am an honorary faculty at various law and IAS training institutes. Now, who could expect some kind of benefit from this series? Well, obviously lawyers and law students, also UPSC IAS aspirants, as well as general public who is desiring to know something about the Constitution of India. Now, I have divided this video series in small videos of 20 minutes or less, at the end of which I assure you, I promise you, that amongst those who know something about the Constitution of India, you will be amongst the top 10%. That's a promise. Okay, that's a promise. Let's go for it. Right? Now, one small thing for my own benefit. If you find this series useful, please like, subscribe and share this video. This is my vested interest in teaching you some great knowledge stuff. Right, let's go for it. Oh, Padmavati. Alright, let's take a guess. Let me see how many of you can guess the topic of today's discussion. So the hints are Padmavati, hints are freedom, Kadni Sena, and the very famous censor board. Yes, my friends, today we are dealing with freedom of speech and expression. What is freedom of speech and expression? Freedom of speech and expression is provided under Article 19(1)(a). This is the right to express one's own convictions and opinions. Now, you can express your own views, your own opinions, beliefs by words of mouth, writing, printing, pictures, or any other mode. Now, this is a good opportunity for all of us to actually appreciate the wisdom of the founding fathers of the Constitution. Just look at it and just appreciate their wisdom. In 1950, when they wrote Article 19(1)(a), they realized that with changing technology, it is possible that citizens will start expressing their views and opinions by some other mode rather than words, writing, printing, pictures. And today, incidentally, we are mostly expressing our views, opinions and beliefs by Twitter, Facebook, social media, internet. This is any other mode. Now friends, one very good query and a very important fact that you realize that this also includes what is called as freedom of press. Very crucial. Let's carry on. Here comes the huge advocate of freedom of press, my favorite, or no? Right? Let's carry on. Now, my friends, another very crucial question. Is this freedom absolute? And what does absolute means? Does that mean that I can do and say anything that I want? No. In a democratic setup, it is better that all of us understand and appreciate that there is no freedom which is absolute. There is always going to be what is called as reasonable grounds of exception. Please memorize these words. Reasonable grounds of exception. The right to freedom of speech and expression is also subject to reasonable limitations imposed under Article 19 subclause 2. So, just to recap, Article 19(1)(a) provides you with the freedom of speech and expression, and Article 19 subclause 2 will provide you with the exceptions thereof. Now, what are these exceptions? Number one, security of the state. So, don't exercise this freedom which violates security of state. If it violates friendly relationships with foreign states, sorry, you're not allowed. If it violates public order, not allowed again. Or just the topper material fact for all of you, please remember public order as an exception under Article 19 subclause 2 was not present in the original Constitution. It was added later by the Constitution's first amendment in 1951. This is one good trivia for you to remember. And of course, you cannot violate decency or morality. This is punishable under section 292 to 294 of Indian Penal Code. Indian Penal Code, by the way, is the law of crimes. So, don't violate security of state, don't infringe on friendly relationships with foreign states, don't disturb public order, don't hurt the feelings of decency or morality. You're good to go. These are first four. There are three more exceptions. We'll continue. The next exception is contempt of court. So you cannot exercise freedom of speech and expression to do what is called as contempt of court. You cannot utilize this for defamation, and you cannot do this to incite an offense. Incitement to an offense was also added by the first Constitutional Amendment Act 1951. Incitement to an offense is actually bhadkana, to somebody to commit an offense. So contempt of court. What is contempt of court? In one line, if you are voluntarily, willfully disobeying the order of an honorable court, whether it is Supreme Court or the High Court, or you are obstructing with justice, you may be playing with what is called as contempt of court. Defamation, the very infamous spat between Arvind Kejriwal and Arun Jaitley is an example. We'll deal with this in detail in later chapters. And of course, incitement to an offense. So, there are 7 exceptions as provided under Article 19, Subclause 2. Are you unhappy? Don't be. Because although these exceptions are provided under Article 19, Subclause 2, what is crucial is this, that these are the only restrictions available against the freedom of speech and expression, which means the state cannot create some new exception. Only those written in black and white clear terms are the ones which you can utilize to stop me from expressing my views, opinions and beliefs under Article 19(1)(a). So please remember, these exceptions have to be clear, these exceptions have to be written, and these cannot be arbitrary, these cannot be ambiguous. Good. So we carry on. So can the state censor the press? Can they tell the press what to write and what not to write? Can they infringe what is popularly called as freedom of press? No. But it is not the case that it has not been attempted. In fact, it has been attempted several times in the past. And every time the state has tried to take away freedom of press, even if they wanted to touch it, the Honorable Supreme Court has come to its rescue. The first case which you should know of was the Sakal Papers Limited versus Union of India, in which an order called as the Daily Newspapers Orders of 1960, which actually aimed to limit or fix the number of pages and the size of the newspaper, was held unconstitutional. That is also called as ultra vires by the Honorable Supreme Court. And then the very famous case of Bennett Coleman and Company versus Union of India, in which the newsprint control order of the then Indira Gandhi government was declared as unconstitutional. Both of these were on the grounds of violation of Article 19(1)(a). So the Honorable Supreme Court has been zealously protecting the so-called freedom of press. Make sure you remember both of these cases. We continue in the next part. However, there is something very funny and something very different about film censorship. I'll borrow it from Honorable Supreme Court itself. Okay, there was a very famous case called as K. Abbas versus Union of India, in which the Honorable Supreme Court said so. These are words exactly from the Supreme Court judgment. It says, films have to be treated separately from other forms of art and expression. Why? Because a motion picture is able to stir up the emotions more deeply than any other product of art. So, the Honorable Supreme Court in the case of K. Abbas versus Union of India has actually decided to keep films, movies, motion pictures on a completely different pedestal. So, Tiger Zinda hai. Let's carry on. So, what does the law say about censorship? Now, if any law has to be made regarding censorship of films, that power is vested to the Parliament in entry 60 of the Union List of the 7th Schedule. Similar powers are also present with the state under entry 33 of the State List. But however, the state law is subject to the provision of the central legislation. So the states cannot make a law which is contradicting or opposed to central laws. The main law with regards to censorship of movies is called as the Cinematograph Act 1952. So again, a very funny thing. Please understand. We were making movies ever since Alamara and Raja Harishchandra. But censorship as a law came far later, 1952. And the associated law rules are what are called as the cinematograph rules of 1983. So when you talk of censorship, We are talking of one act called the Cinematograph Act and the associated rules called as Cinematograph Rules 1983. This is the much feared, much talked about censor board. Censor board is technically called as CBFC, which is Central Board of Film Certification. It answers to the Ministry of Information and Broadcasting, and it is responsible to certify movies into categories. The first famous category, easy category, is called U. So you will get a certificate called as U, which is unrestricted public exhibition. Everyone of every age group can go and watch this movie. And on the other extreme is A, which is the adult, restricted to adult audiences. Most of us know what we are talking of. The third one, which is somewhere in the middle, is called UA. That is, it is unrestricted. However, if the child is below 12, then he has to watch it under the protection or so-called parental guidance. So his parents or guardian should be around him. And then there are some special certificates called S, which are restricted to specialized audiences such as doctors or scientists. But the crucial and the most dangerous part is the board may also say, we don't want to certify. We refuse to certify. And here comes the trouble. So, what is the problem? The first, the composition of CBFC. Now, what is Central Board of Film Certification made up of? It is made up of one chairperson and 25 other non-official members. All of which, I repeat, all of which are appointed by the central government itself. Second, I discussed this when I discussed Article 19 subclause 2, that these are the only grounds of restriction of Article 19(1)(a). That is, my freedom of speech and expression will be limited only by Article 19 subclause 2. But no, not in this case. Central Board of Film Certification has its own set of rules on the grounds of which they can either refuse or may certify some movie according to whatever whims and fancies, but written in that rule, not written in the Constitution of India. So what does it open the gates for? It opens the gates for what are called as state interference. So the state can decide which movie it wants to show, which movie it does not want to show. So, the Padmavati saga. Now, what does this expose? Central Board of Film Certification is acting as a quasi-judicial body. It is actually making laws unto itself. Is it acting like a puppet of the central government? Maybe. And this is the main criticism. The CBFC is actually deciding on the basis of what Ministry of Information and Broadcasting is telling it to do. Third, is cinema censorship not the same as censorship of information? I want to watch a movie. Movie can also be an information. Movie can be a documentary. I want to watch this movie. Who's stopping that? The central government may stop it. Okay. So, this is the third controversy. And the very important question. We took this concept of freedom of speech and expression from the first constitutional amendment of USA. Way back, when they formed the first constitutional amendment, which provides them, the Americans, as freedom of speech and expression, they are zealously guarding it. Why are we diluting it? It's $1 million question. So, these are the questions that emanate from the Constitution, but has to be answered by the government and the citizens and the courts alike. So, this, in conclusion, is Padmavati saga opening our eyes once again to whether or not do we need freedom of speech and expression, or whether or not do we need film censorship. Enough, I hope. If you have any doubt, feel free to mail me on siddhartharoraofficial@gmail.com. If you know this much, I promise you're on the way to become a champ. Until next time, take care. Please don't forget to like and subscribe to this channel. Until next time, thank you.